Hi, I'm James,
And I'm Liv.
and this is the Criminal Maze podcast.
And today we will be talking with Oliver Kirk, who is a barrister at 5 St Andrews Hill Chambers in London.
Well, thank you for joining us.
Thank you very much for inviting me on.
And you are a barrister.
That's right. I'm a barrister at a set of chambers in London, but just because I'm in chambers in London doesn't mean I practice in London. I practice mostly over the southeast, but also further away. And I both prosecute and defend, but most of my practice has involved defending over the last 20 odd years, during which time I've been both a solicitor and a barrister.
It's fantastic. We're going to ask you later on about prosecution work you do. But if we start, you mentioned then that you have been a solicitor and a barrister. So I too have high rights of audience, solicitor advocate. So if you could explain, why did you decide to become a solicitor?
I became a solicitor back in 1996. That's when I qualified. I had been to Manchester Metropolitan University. It was actually Manchester Polytechnic at the time, and came out.
My mum then.
I left there just as Black Wednesday hit. And all my ideas of being able to go off and work in Europe doing commercial law came crashing down around my ears as big commercial firms simply stopped taking on significant numbers of trainees. And so I spent a long time looking for a training contract, but managed to get one in a small high street firm in Ramsgate, right down in the southeast of England. I started off doing criminal work, and it was incredibly satisfying. It was great to be able to advise people and help people who I thought needed my help, and to be able to speak for them in court. And I fairly quickly realized that that was something I was far more interested in doing than commercial work, which can be very dry and perhaps satisfying in a different way. It's exceedingly well paid, but I suddenly thought to myself, I found my calling. And I very much liked standing on my hind legs in court and representing people.
I think we're probably both quite biased in that criminal law is the most interesting area of law.
Yeah, of course it is. Being a criminal lawyer basically can be a license to be nosy. You hear about the most appalling things that people do to each other.
And how do you feel? Because I get asked quite a lot, how do I represent people that are clearly guilty? Is that something that you get asked?
It is something. It's the classic question, and nobody sort of asks the obvious opposite question of prosecutors. How do you prosecute someone who you think is innocent? The fact of the matter is, and I learned this very early on, that it's quite important not to start judging your client. It's very counterproductive. It means you can't really be objective. And of course, you should look very closely at what your client says and whether it's credible and whether there's evidence to support their account. If you go around forming a view that your client is guilty, you may end up effectively being involved in a terrible miscarriage of justice.
Do you find then it's kind of an academic question to think that, well, everybody's innocent?
Well, that isn't academic. That is exactly the approach of the courts. And you know, the way I address a jury in a speech, if I'm defending, is even though you have seen the defendant sitting in a dock and the very first thing you've heard about him is all these horrible things he's alleged to have done, you have to start with the presumption of innocence. So start your deliberations in assuming or presuming that the defendant isn't guilty, and then ask yourself whether or not the prosecution have proved it, and if they have proved it, have they made you sure? That's a helpful way of approaching it. But equally, as you say, it is slightly academic, because very often by the time I get hold of a case, the defendant has already been interviewed. They may have made admissions. And it would be completely absurd for me to go around automatically assuming that people who have confessed are innocent. Obviously, I will check with them that their confession was a true one and that they haven't admitted things to try and get somebody else out of trouble or for whatever reason. But if you are instructed in a case where somebody is denying it, then that is what you run with, and you look at what the prosecution can prove and whether they have admissible evidence and so on.
So what made you decide to become a solicitor advocate?
I discovered literally on the very first day that I was a solicitor advocate, and I was sent to Canterbury Magistrates Court to do a trial where I received the papers in the morning, that actually trial advocacy was something I really enjoyed. And over a period of time, the position went from no solicitors could appear in the Crown Court to more and more solicitors were getting what are called higher rights of audience that permit solicitors to appear in the Crown Court and indeed Court of Appeal. And so I decided that I would apply for those higher rights of audience. I got them about 10 or 11 years ago now, and have exercised them an awful lot ever since.
So what is the transfer then from becoming or being a solicitor advocate to becoming a barrister?
You need to make an application, first of all, to be called to the bar at one of the Inns of Court, and you make an application also to the Bar Council for exemption from pupillage, or that's the way I did it. And if you didn't have the same level of experience, you simply make an application to be allowed to practice at the bar. And the Bar Council will then either say that you have to do a 12-month pupillage or a 6-month pupillage, or as in my case, no pupillage at all. But I am supervised for 3 years just to make sure that I'm adjusting appropriately, if I could put it like that. And so, yes, it was a relatively straightforward process, one that I have to say I kept putting off, but I got there in the end. I'm very pleased I did.
And it's completely optional for a solicitor advocate to wear a wig, isn't it? So just wondering, did you decide to wear a wig?
I did decide to wear a wig, partly because I thought that it would be a distraction if I didn't. And I know that different people have different views. The first solicitor advocate I saw in action was fairly early on in my career, actually, and he didn't wear a wig. And he was brilliant. In fact, he's now transferred to the bar. And I thought to myself, you're allowed to wear a wig, you should, because otherwise you sort of stick out like a bit of a sore thumb in a business.
Yes.
It then becomes about you, and people wondering, well, why isn't he wearing a wig? You know, perhaps he's got some sort of horrible scalp infection, which of course is why wigs came in the first place. But anyway.
Well, I was going to ask, why do barristers wear wigs and gowns?
Well, it's historical, of course, and it goes back to the time when everybody wore such things. And it is thought that it provides a certain anonymity to court proceedings. So judges wear wigs and gowns, and barristers do as well. And they don't necessarily wear them in all proceedings. Nowadays, we don't have to wear them when we're appearing on a video link hearing, except in the Court of Appeal. But I am a big fan of it because it does make people look very anonymous. It is quite possible sometimes to walk past a member of the bar who you've seen wearing a wig and not recognise them when they are not wearing their wig. But it does also look completely archaic, and particularly in looking at a lot of the modern courtrooms that we have, you do feel slightly ridiculous walking around with what looks like a dead sheep on your head, and wearing a gown that would be more at home in sort of Pride and Prejudice times. But no, it sort of almost feels when you put it on like it's a sort of suit of armour. Yeah.
I wonder as well, perhaps as a benefit, because you do form this bridge between your client but then remaining an officer of the court, so you need to make the distinction between yourself and a lay person, perhaps?
Yes, I think so. No, that's definitely part of the it's in academic circles referred to as the semiotics of the law, isn't it? Where we're all sending out signals as to who we are, and it also has to do with public perception. I've recently been appearing in one of the Nightingale courts, which have been set up to try and cut down the backlog, and so I've been appearing in a Marriott hotel wearing a wig and gown, which again feels slightly absurd. There you are in a room that is normally used for things like weddings, conducting a serious criminal trial. And I think that wearing a wig and gown in those circumstances actually reinforces the solemnity and importance of the proceedings. It's easy to forget as a lawyer that what you're doing in court will probably be one of the most important days of somebody's life. It can literally be the difference between whether they go to prison and never work in their chosen field again, or whether they don't go to prison or are found not guilty. These are life-changing moments, and you don't want people wearing fancy ties or distracting suits or silly haircuts. It's a good leveler to have everybody wearing that uniform so that people are concentrating on the evidence in court rather than on extraneous matters.
And if you were able to speak to your younger self or a law student starting out, would you recommend the route you took to the bar, or would you suggest a pupillage?
That's an interesting question. When I started out, I simply did not think that I was the sort of person who would be able to go to the bar, because I hadn't been to Oxford or Cambridge, and I hadn't studied law at one of the leading universities. And the idea that I could have become a barrister, I would have found quite surprising. However, over time, of course, the makeup of the criminal bar has changed. And that is for a number of reasons. First of all, of course, society has changed, and the bar is much more open and diverse than it used to be. But also, a lot of the bar have moved on from crime. And the reason for that is that fees have remained pretty much static since I qualified, which is pretty extraordinary given that that was now a quarter of a century ago.
Conversely, do you think that because the wages have stagnated for so long, sometimes I've read some people's view on it where it's been that you need to have a kind of private income in order to start out now, or as a pupil in London in particular?
I qualified in a different world. I went to a polytechnic and had a full grant. I was able to take out a student loan my last year, which was £500, and that was the maximum amount I was allowed to borrow. Students now are coming out, particularly on the end of the bar professional course and solicitor's equivalent, on the wrong end of about £60,000. And to spend all of that money, invest all of that money in your future to discover that as a solicitor you might be earning less than £30,000 for most of your career is really unacceptable. And I think a lot of people, although they're very motivated to go into crime, because it's fascinating, it's interesting, it's exciting, if it isn't paying the mortgage, then you can't do it.
Of course. And if you would take a case from the start to finish, if a solicitor phones up your chambers and asks to instruct you, how does that process start?
Well, the clerks will obviously have a look at the barrister's diary and see whether they're going to be available for the initial hearing or the sentencing hearing or whatever it is, and look at availability generally. As you all know, we're not allowed to refuse cases because of what's called the cab rank rule, but that is subject to being available. and indeed subject to it being a case that we feel adequately qualified to deal with. So subject to that, I would then get a telephone call from my clerk telling me that such and such a solicitor had wanted to instruct me in such and such a case, and we've put it in the diary. And then it's a question of receiving the papers or the invite to the digital case from the solicitors, looking at the papers and arranging then perhaps initially for a discussion with the solicitor about the case without the client, so that we just get a feel of the general direction of travel, and then no doubt having a conference with the client discussing the various options and preparing either for a trial or preparing for sentence.